3 weeks ago, our country crossed a tragic milestone. We lost more than 200,000 Americans to COVID-19. That is more than the entire population of the Big Island in Hawaii, more than the population of Tempe, Arizona, Cedar Rapids, Iowa, Wilmington, North Carolina, Charleston, South Carolina, Waco, Texas. I could go on. 200,000 American lives plus. This is a photo of a memorial outside the White House where President Trump held a reckless super spreader event 2 weeks ago to announce the Supreme Court nomination. The memorial shows 20,000 empty chairs, one chair representing 10 American lives lost to COVID-19. And one of those chairs represents Veronica Guevara's grandfather, who is pictured here with Veronica. Veronica, who is from Iowa, has experienced the painful impact of the Trump administration's failure to address the pandemic. Her family is composed of essential workers who are working on the front lines of this pandemic. Her mother, who worked at a fast food processing facility, caught COVID-19 at work and was eventually hospitalized for 7 days. Thankfully, her mother recovered, but then her grandparents got COVID-19 and were admitted to the hospital. And although her grandmother recovered, sadly, her grandfather didn't make it. After experiencing all of this tragedy, Veronica shared, quote, "It is even more so insulting to see a Senate that is more concerned with rushing through a Supreme Court nominee rather than focusing on providing relief to all the hardworking people that gave them their current leadership positions," end quote. Many Americans agree with Veronica. They are sitting at their kitchen tables wondering how they're going to buy food, how they're going to pay rent. Millions of them are they don't have jobs. They're going to food banks for the first time in their lives. So rather than coming up with a bill that meets the needs of the urgency of this moment, Republicans are just coming up with piecemeal bills. That's because we know that within your own caucus, you can't agree on one bill that fits the critical needs of this country. In fact, there are at least 20 Republicans we heard who have said, we're done, we're not doing any more to help the Americans who are suffering with COVID. So here we are racing forward with this nomination while the rest of the country is wondering, what the heck is the Senate doing, particularly the Senate Republicans? So I agree with all the people in our country who are asking, what the heck? This is hypocritical. This hearing shows the American public exactly what my Republican colleagues' priorities are, ramming through another ideologically driven justice to the Supreme Court instead of helping the people in our country suffering during this pandemic. Mr. Chairman, I have some letters of opposition to Judge Barrett's nomination to enter into the record. These are letters from Lambda Legal, the Japanese American Citizens League, and the National Asian Pacific American Women's Forum, which was joined by 55 reproductive justice groups. I ask unanimous consent to enter these letters into the record.
Without objection.
Judge Barrett, Chief Justice John Roberts has recognized that, and I quote him, "The judicial branch is not immune," end quote, "from the widespread problem of sexual harassment and assault, and has taken steps to address this issue within the judiciary. As part of my responsibility as a member of this committee, and indeed all of the committees on which I sit, to ensure the fitness of nominees for a lifetime appointment to the federal bench or to any of the other positions for any of the committees on which they appear, I ask each nominee these two questions, and I will ask them of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator Hirono.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
Judge Barrett, do you think it is appropriate for justices to consider real-world impacts in their decision-making, as Justice Ginsburg noted in a number of her dissents?
Well, Senator, the doctrine of stare decisis is a good example of that because the factor reliance interests takes into account the real-world impact, the way that people have ordered their affairs and relied on decisions. So there are contexts, yes, in which considering the impact is expressly part of the doctrine.
So you would say then that you've been listening to all of us here yesterday as well as today talk about the real-world impact of the striking down of the Affordable Care Act, and would all of those impacts be factors that would be important for you to consider should you be a justice?
Senator, to be clear, I have the utmost empathy. The stories, that you have told, including the story of Veronica's family, are very moving. If I were a justice, the commitment that I would make to you and all people affected by the laws is that I would follow the law as you enacted it, and I have no agenda. I would not be coming in with any agenda. I would do equal justice under the law for all and not try to thwart or disrupt in any way the policy choices that you and your colleagues have adopted.
So are you saying that the impact of the Affordable Care Act on the millions of people who rely upon it, that those who you would deem to be policy considerations that we should address?
Senator, I think that you choose the law, and you've structured the Affordable Care Act. It's a complex, long statute. I think you set the policy, and then I think when a court has to interpret the statute or decide how it applies in a certain circumstance, the court looks to traditional legal materials, looks to the briefs. It listens to the real-world impact on the litigants who are before the court arguing the case, because every case affects real litigants. Every case affects real people. I said in my opening statement yesterday that, when you pass statutes, they're often named for the co-sponsors of the bill. But cases decided by all courts are typically named after the parties. They affect real people.
Judge Barrett, so are you saying that all of the stories that we brought forth yesterday and the millions of people who are relying on the Affordable Care Act can rely upon you, that those impacts would be considered by you, that you would consider those to be legal arguments that you would consider? Because when you say that you're going to make a decision based on the law, the real-life stories that we've been talking about, you would consider those to be part of the law?
Senator Hirono, every case that comes before a court, because as I was saying earlier, no case comes before a court unless it involves real live people who've had a real live dispute. And it is the job of a judge deciding every case to take into account the real world consequences of the parties before it.
So does that mean that you would agree with Justice Ginsburg that the court should be taking into consideration the real-life effect of the decisions that they make? Because she wrote a number of dissents saying that the majority did not consider the real-world impacts of their decisions. So are you aligning yourself with Justice Ginsburg in terms of what you would consider real-life impacts and the effect it would have on your decision regarding the law?
Well, Senator, I don't know what context, the particular context in which Justice Ginsburg was describing that. I think what I'm trying to align myself with is the law, and that I will take into account all factors, including real-world impacts, when the law makes them relevant, as it clearly does, for example, in the doctrine of stare decisis.
I'll get to your views of precedent in a moment. I'll give you a real-life example of Justice Ginsburg. In Ledbetter v. Goodyear Tire and Rubber Company, Lily Ledbetter worked at a Goodyear plant for 19 years. As an area manager, a position held mostly by men, Lily was paid less than all of her male counterparts. When she eventually realized this stark inequality, she sued for pay discrimination, and a jury agreed. But the Supreme Court kicked Lily's claim out of the court for being too late. The conservative majority, including your mentor, Justice Scalia, interpreted Title VII's 180-day time limit to mean that Lilly had to have filed her claim within 180 days of when her salary was decided, instead of accepting the common sense approach of viewing her paychecks as an ongoing part of pay discrimination. Justice Ginsburg strongly disagreed with her conservative colleagues' approach to the case. In her dissent, she pointed out the many challenges women face in discovering pay disparities, including how many companies keep salaries confidential. In a stinging rebuke, she said, quote, "The court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination," end quote. In another case, in 2018, in Epic Systems Corp v. Lewis, employees who had been illegally underpaid joined together to seek back pay in court. To block this effort, their employers forced them to sign an arbitration agreement prohibiting collective actions. They actually had to sign these arbitration agreements in order to even have a job or keep their job. So the Supreme Court's conservative majority, including Justice Scalia, sided with the company. They interpreted a general federal arbitration law to override two worker protections laws instead of recognizing that the worker protection laws fall sensibly within the exceptions in the arbitration law, meaning that the worker protections laws should prevail. Again, Justice Ginsburg strongly disagreed with the majority's approach to the case. In her dissent, she pointed out that blocking joint lawsuits would deter most workers from seeking individual unpaid wage claims because of the cost of lawsuits and fear of retaliation. She warned the majority's decision would result in hurting vulnerable, low-wage workers. Now, those are the kinds of real-life impacts. The reality of women who are not paid the same as their male counterparts because of sex discrimination happening that she has no way of finding out about, or of workers who are forced to sign an arbitration clause that overrides worker protection, other worker protection laws. Those are the kind of real-world impacts. So do you think Justice Ginsburg was wrong to consider real-world impacts in her decision-making?
Well, Senator, both the case, you're talking about Lilly Ledbetter, both that case and Epic Systems are precedents of the court. And as I've said a number of times during the hearing, I can't really comment or grade thumbs up or thumbs down, as Justice Kagan put it, prior precedents, or say how I would have decided them.
They are, Judge Barrett, they are precedents of the court that do not take into consideration the real-world factors at play here. And in fact, in the case of Epic Systems, the court sided with the corporation as opposed to the workers who are trying to remedy a wrong. And in Lilly Ledbetter, she was totally out in the cold. So again, the court did not. So they established precedent, all right, but it was a precedent that was not based on real-life impacts. So much as you sit here telling me that you would follow the law, after all, the law, for example, the Affordable Care Act, that law embodies a policy that says we want as many people as possible to be covered under insurance. And if the Affordable Care Act is struck down, that policy, that law, would be struck down. So I know that there was some discussion about some distinction that you make about policy versus the law, and I find that distinction to be a fiction, because every law, or most laws we pass, are supposed to have real-world impacts. Otherwise, why should we pass a law? So the fact that you're not able to, I think it's pretty clear. Let me rephrase that. You do consider Justice Scalia to be your mentor, that your judicial philosophy is in alignment with him, and I think we all acknowledge that Justice Scalia and Justice Ginsburg were at pretty much opposite ends of the spectrum. So since Justice Ginsburg made it a policy, her approach was to look at the real-world impact. Justice Scalia's was not. So I'd say that when it comes to the Affordable Care Act, the real-world policy considerations that will not be taken into consideration by the conservative judges would mean that 23 million people could lose their health care, that 133 million Americans with pre-existing conditions could lose critical protections for their health care, and more than 7 million Americans who have tested positive for COVID-19 would probably be added to the group of people with pre-existing conditions, and millions of Americans would once again face lifetime limits on coverage for essential services. That 8.7 million women would lose coverage for critical maternity care services, and we know that Black and Native women are 2 to 3 times more likely to die than white women from pregnancy-related cases, that Americans could lose coverage for essential health benefits like prescription drugs and mental health care, that young adults will no longer be able to stay on their parents' health insurance plan until age 26 at a time when our country is dealing with massive job losses. So in my view, you have posed an artificial distinction between policy considerations that's left up to us and following the law, because if your criticism of Justice Roberts' decision in upholding the Affordable Care Act, if that was something that he followed, he would have struck down the Affordable Care Act. That is your, if he followed your criticism of him in sustaining the Affordable Care Act, he would have struck it down. So I would conclude that your approach is, in fact, not like that of Justice Ginsburg, who did care about what would happen. Let me just tell you one story of a person who will be impacted in the real world if the Affordable Care Act is struck down. And I know that so many of my colleagues have already established that the president expects you to strike down the Affordable Care Act, and you've already established that you made no such commitments. But clearly that is why this whole process is occurring so that you can be sitting on that court in time to hear the Affordable Care Act by the Supreme Court on November 10th. So one of the people who will be impacted is Elizabeth from Texas. She moved to Texas for a job and thought that she would have a stable income and health care coverage. And all that changed when her hours decreased and she lost her health insurance. Because she couldn't afford health insurance, she couldn't get proper treatment for her asthma. She had to resort to using friends' expired inhalers and over-the-counter remedies. The ACA allowed her to get health insurance again. The ACA also protects people with pre-existing conditions like Jordan, who I talked about yesterday, and she has a very rare illness that would require $500,000 per year just for her medication. And were it not for the Affordable Care Act, she wouldn't be able to afford it. I mean, who can afford $500,000 a year to keep her going? And also people like Kimberly. I talked about her yesterday. The ACA enabled her to get a mammogram, which she wouldn't have been able to get, and that mammogram revealed that she had breast cancer, and she got a mastectomy. So, you know, the real life impacts on people like Elizabeth, Jordan, and Kimberly, where you say you will follow the law, it really leaves me wondering whether all of these real life impacts are what you would call within the scope of the law that you would decide should you be confirmed. November 10th, you'll hear the case. You will be deciding on the constitutionality of the Affordable Care Act. And by the way, you noted that the issue in the Affordable Care Act was one of, what was it that you said?
Severability.
Severability. But the other issue in the Affordable Care Act is the entire constitutionality of the law, because the district court, the issue was whether the district court in Texas was correct in deeming the entire law unconstitutional. So in fact, we are facing the entire law falling by the wayside. Let me move on. So you've been also asked a lot of questions about whether or not you would overturn Roe v. Wade. I mean, clearly President Trump expects that you would do so because, as he said, if we put another 2 or perhaps 3 justices on the court, that'll happen, meaning the reversal of Roe v. Wade will happen automatically, in my opinion, because I am putting pro-life justices on the court. And a number of us have mentioned that as far as Senator Hawley is concerned, where he said, I will only vote for those Supreme Court nominees who have explicitly acknowledged that Roe v. Wade was wrongly decided. And there's a whole quote I have from him, but after you were nominated, Senator Hawley made clear that you passed his litmus test. And he said, I think her record is awfully clear. I think that's one where she meets my standard of having evidence in the record. And by the way, he had noted that he expected this evidence in the record, not from your post-nomination assurances to him. So all your prior record, he said, you met his standards. So we usually expect justices to uphold and apply long-standing precedent. So was the president wrong in concluding that you would vote to overturn Roe v. Wade?
Well, Senator, again, I can't make any statements, no hints, forecasts, or previews, as Justice Ginsburg put it, about any case or any precedent, but I will repeat what I've said, throughout this hearing, that I made no promises to anyone. I have no agenda. There are 598 volumes of the United States reports. That's something that judges build on. Justices don't go to the court to start having a book burning.
I know that you have reiterated that time and again, but what we are left with are the positions that you have already taken. So the 2006 newspaper ad you signed that said you, quote, oppose abortion on demand and defend the right to life from fertilization to natural death. It's not just the fact that this newspaper ad you joined said what I just read, but it also said, quote, it's time to put an end to the barbaric legacy of Roe v. Wade. In a 2013 speech you gave where you said the Roe decision, quote, permitted abortion on demand, end quote, after you said you opposed abortion on demand in 2006. So what underscores my concern about your willingness to overturn Roe v. Wade, which is really the expectation that the president has and which Senator Hawley fully expects you to do because you have met his litmus test. But you noted stare decisis, which is precedent, and you have argued that a justice's duty to follow the Constitution, which you explain means that she should, this is regarding your view on precedent, that she should, quote, enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it, end quote. So in fact, you said constitutional cases are the easiest to overrule because you bring your own assessment of what the Constitution requires. And as you said, if the precedent is clearly in conflict with your view of the Constitution, then the precedent falls by the wayside. So you did indicate that there are a few cases that are immunized from overturning because they wouldn't be challenged in the first place, i.e. Brown v. Board of Education. But Roe isn't one of those cases because we know that there are all kinds of challenges to Roe, basically because the states are very busy passing all these laws that limit a woman's right to an abortion. So you also said in that speech that even if Roe is not overturned, you said, without overturning Roe, you explained, quote, the question is how much freedom the court is willing to let states have in regulating abortion. And so there are 14 cases right now relating to state abortion restrictions making its way through the circuit court, and some of these are going to land in the Supreme Court. And these 14 cases include the following restrictions. 6 cases involve bans on abortion starting at gestational ages ranging from 6 to 24 weeks. 2 cases involving bans on a particular type of procedure, dilation and evacuation, that accounts for nearly all second trimester abortions. 1 case involving a requirement that fetal remains be buried or cremated. 4 cases involve laws imposing unnecessary requirements on abortion providers, like transfer agreements with local hospitals. 4 cases involve so-called reason bans. 2 cases related to parental notification and consent. There are real reasons why the American public is concerned that you will overturn Roe or basically strip it of all meaning so that it becomes a nullity, because you will have these cases that, as you say, the open question is how far the Supreme Court will go in letting states put limits on abortion. So that is why a lot of people are very concerned about your views as articulated pre-nomination, which convinced Senator Hawley you met his test. This morning, Senator Feinstein asked you a question about the Supreme Court's 2015 decision in Obergefell v. Hodges, a case in which the court recognized the constitutional right to same-sex marriage. And I was disappointed that you wouldn't give a direct answer on whether you agreed with the majority in that case, or if you instead agree with your mentor, Justice Scalia, that no such right exists in the Constitution. So even though you didn't give a direct answer, I think your response did speak volumes. Not once, but twice. You used the term sexual preference to describe those in the LGBTQ community. And let me make clear, sexual preference is an offensive and outdated term. It is used by anti-LGBTQ activists to suggest that sexual orientation is a choice. It is not. Sexual orientation is a key part of a person's identity. That sexual orientation is both a normal expression of human sexuality and immutable was a key part of the majority's opinion in Obergefell, which, by the way, Scalia did not agree with. So if it is your view that sexual orientation is merely a preference, as you noted, then the LGBTQ community should be rightly concerned whether you would uphold their constitutional right to marry. I don't think that you use the term sexual preference as just, I don't think it was an accident. And one of the legacies of Justice Scalia and his particular brand of originalism is a resistance to recognizing those in the LGBTQ community as having equal rights under our Constitution. In 1996, Justice Scalia wrote a dissenting opinion in Romer v. Evans defending a state's ability to openly discriminate against the LGBTQ community. In 2003, Justice Scalia wrote a dissenting opinion in Lawrence v. Texas defending a state's right to criminally prosecute someone for same-sex sexual activity. 10 years later, in U.S. v. Windsor, Justice Scalia wrote another dissenting opinion, this time defending the federal government's right to deny federal recognition of same-sex marriages. And of course, 2 years after that, in Obergefell, Justice Scalia wrote yet another dissent, and this time he argued that there was no constitutional right to same-sex marriage. So under Justice Scalia's judicial philosophy, which you have told us is your own, states could openly discriminate against the LGBTQ community. Same-sex couples could be denied the right to get married, and they could actually be thrown in jail if they engaged in sexual intercourse. There are an estimated 11 million adults who identify as LGBTQ living in this country since Obergefell was decided in 2015. Approximately 293,000 same-sex couples have gotten married. And many of these people are rightly afraid that if you are confirmed, you will join with other conservative members of the court to roll back everything the LGBTQ community has gained over the past 2 decades and push them back into the closet. Now, 2 sitting justices are already calling for Obergefell to be narrowed, if not outright overturned. Just last week, Justices Thomas and Alito issued a statement concurring with the court's decision to deny cert in Davis v. Irmo, a case involving a former Kentucky County Court who refused to issue marriage certificates to same-sex couples. They accused the court of, and this is Justices Alito and Thomas, they accused the court of, quote, reading a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. And these 2 justices signaled that Obergefell is a problem that only the court can fix. So, coupled with your use of the term sexual preference, coupled with your view on precedents, and that a justice's view or her own analysis of the constitutionality should overtake or overcome precedents if it's in conflict. So This is why so many people in the LGBTQ community are so concerned that you would, in fact, join the signaling that these two justices have already put out there, that Obergefell will fall by the wayside. Thank you, Mr. Chairman.
Thank you. Senator Ernst.
Thank you, Mr. Chair. And Judge Barrett,